Good afternoon, and thank you everyone for joining us for today's webinar on modifying custody orders. We'll be getting started in just a few minutes here. Thank you for your patience. All right, we have 12 o'clock, so we'll get things started. Welcome and thank you for joining today's webinar, Modifying Custody Orders. During today's session, Michael Belsky, a partner based in our Albany office, and Paul Tortora, a senior associate in our Syracuse office, will present a comprehensive overview on modifying your custody order. Key topics that will be covered today include burdens of proof, change of circumstances, and best interest standards, evidence, and evaluations. Throughout the webinar, all attendee microphones will remain muted. Following the presentation, we'll open the floor for a question and answer session. To submit questions for Michael and Paul, please use the chat function, which can be found located at the bottom of your screen. The icon is a small chat bubble. Today's webinar will be recorded, and a copy of the recording will be shared with all registered attendees. Without further ado, we can get things started. I will pass the mic to Michael and Paul to begin the presentation. Paul, I'm not able to hear your audio.
Sorry, can you hear me now?
Yes, thank you.
Okay, apologize about that. Okay. So I think Mike and I have already been pretty thoroughly introduced, so I think we can go on to the next slide and get this started. Okay, so burdens of proof. The burden of proof is simply who needs to prove their case. In this context, it's who needs to show that the existing agreement needs to be modified. That burden is going to be on the party who wishes to modify the agreement, so the person filing the petition. Usually, you have to present some sort of evidence in your petition that there is a change of circumstances and that there's a best interest of a child. There's kind of two steps to this process. The first thing you need to show, and we'll get into this in more detail in the next slides, is a change of circumstance. If you can show the court that there is a change of circumstances that has occurred that necessitates a change to the existing order, then the court will go on and determine if changing that order is actually in the best interest of the child. You can go to the next slide. Okay, an important thing, probably the most important thing to remember when you want to modify a custody agreement is we're only talking about things that have happened since the last order. If the order was issued 3 years ago and there was, say, domestic violence or an arrest or something that had occurred 5-6 years ago, it had to have been dealt with at that time. We can't bring it up now. I mean, it's tough for a lot of people to understand. They want to bring up the past and all of that, but the way that the court views it is that that was taken into account in making that last order. So we can't go back and rehash it and relitigate it. So it has to be things that have happened since the last order. Change of circumstances, there's no definitive list of factors. You're not going to find any law out there, any statute that lists what you're supposed to consider. It's kind of a nebulous idea. It's a question of fact for the court to consider. But there are some things that they will look at. I mean, an obvious one would be the relocation of one parent. If someone moves or intends to move, that would obviously be a major change of circumstances. Depending on if they're moving down the street, not necessarily, but if it's a distance where it's going to affect the other parent's ability to access the child and to be part of the child's life, that's certainly a change of circumstances. A common one is changing household composition. Oftentimes people have new boyfriend, new girlfriend, they get remarried, step siblings move in, there could be new roommates, those type of things. And what that alone will generally not get you a change of circumstances. What will is the relationships between the child and the new people living there, whether it be a new spouse, boyfriend, girlfriend, their children, the effect that this living situation could be having on the child. Are they now having to share a bedroom with a child they don't know? Are there 3 or 4 kids in a bedroom? Is there, has it affected the living situation, the sleeping situation? So that's another one. Criminal issues should be a pretty obvious one. If someone is arrested, that can be a change of circumstances. We're usually talking more about something that would affect the child, though. If it's, something, a drunk driving arrest, drug possession, anything with domestic violence, things like that could be changes of circumstances. Drug and alcohol use. If someone has started or increased their use of drugs or alcohol, if they've spent any time in rehab, again, if there's been any arrests involving that, that could be a change of circumstances. A big one is not following the court order. If someone is repeatedly violating the order, if it's the order gives 50-50 custody, but someone has had, in reality, the child 80% of the time the last year, or if it's someone is consistently not showing up for their parenting, visitation time, really any sort of violation of the order could be used to modify the custody petition. If there's issues with exchanges, if somebody's not showing up on time, or there's any sort of confrontations, anything like that occurring, especially in front of the children. One parent is trying to control access to the child. They're supposed to be allowing phone calls, FaceTime, things like that, and they're not doing that. So really, if the order is not being followed, that's something you can always try to use as a change of circumstances. Along those same lines, if there's become a complete inability to co-parent, has to be more than just a disagreement or dislike between the parties. If the relationship is broken down to the point where they can no longer effectively really even speak without yelling at each other or agree on anything, or somebody's just making unilateral decisions, that can be another thing that could be considered. School performance, and that will be how basically, is there major differences between the nights the child spends with the mother and night the child would spend with the father? Is there significant problems there? Is the child showing up to school properly groomed and bathed, prepared for tests, have their homework done? Are they there on time? Are they there at all? Is it affecting test grades? Anything like that? If there's significant differences occurring between nights they're with mom and they're with dad. Domestic violence is another one that is fairly obvious. If that's occurring in the home, especially if the children are in the home when it occurs, if they've witnessed it, or if they have been impacted by it. See if there's anything else I want to add here. Mention also, mental health issues, I guess, is one other thing I'd want to discuss. Has there been any new mental health issues? Is somebody not following the medical instructions? If they stop taking some sort of medication, has there been a breakdown? Has there been a hospitalization? Those type of things could constitute a change of circumstances. Mike, is there anything you want to add? No?
Yeah.
Okay.
Yeah,
Go ahead, Mike.
I'm sorry, I couldn't unmute myself. A couple things that I think also with regards to modifying the custody petition, you have to look at also what type of custody are we talking about? Do you have a joint custodial arrangement with your partner? Do you have a 50-50 relationship with your partner? Or do you have sole legal and physical custody of the child? So these are issues, of course, regarding modification of a custody petition, but they all might relate there. Some of these might relate to what type of custody you have and what you might be bringing up in your petitions. Let's just say you have sole custody of the child And sole custody means that you, as the sole custodial parent, make all the health, education, and welfare decisions for the child without having any other input from the other party. So again, with something like that, if the other party brings up, well, the change is that, well, they're not telling me about what's going on with the child. They're not giving me doctor's notes. They're not informing me of different health and education and welfare issues. They don't have to. When you look at joint custody, they do 50-50, they do. So you also have to look at, exactly what Paul said, but then you have to look at what type of custody you're trying to modify. Also, the biggest thing you have to look at, like Paul said, is that number one, what is the change? And then he's going to go into the second prong now, what is the best interest? So it's not just what the change is. And you see a lot of these petitions filed with attorneys or individuals. They say, well, this has happened. But then you have to say, okay, if we change and do what you want, how is that in the best interest of the child? And that's very important when you fill out petitions, what the change is, and then why it's in the best interest. And I'm just going to go way to the left or right here. Of course, the change is that one of the parties who has primary custody is now, they just got arrested for DWI and they had drugs on them. Okay, so that's the change. But then you have to say, what is in the best interest? Well, of course, it's not in the best interest for the child to remain with that parent based upon these allegations or what's going on. And then you could say, well, I have a better household. I'm not using drugs. I'm more stable. I have a more stable environment. You got to make sure when you put your petitions together, it's a two-pronged test. So when you think about that, really think about it. Now, the last thing that's going to be interesting is Paul has brought up the issue of drugs and alcohol use. Now, with the current case, with the current new laws in New York State about marijuana consumption, and marijuana is legal, okay? But you have to remember that a lot of times with marijuana use, there's laws that basically set forth you can't drive in a car with a child and be under the influence of marijuana, just like you can't with alcohol. But the big thing that's going to be, it has not come up yet, but this is a case that I'm going to probably see in the very near future, and I would actually litigate this case if I was retained on this. Mom and so the child's at one of the parents' house. It's New Year's Eve. They're inside in the house. And of course, if there's alcohol in the house, you can keep a pretty good idea of what's going on with the alcohol and that the child's not drinking. But let's just put it this way, that the child's in the house with the parent and they're smoking pot. All right. Now, the child's not smoking pot, of course, but as we all know, when you look at cigarettes, secondhand smoke is a major issue regarding cigarettes, but it's not illegal, okay, if you're smoking in the house and a child's there. But my contention would be if someone is smoking a lot of marijuana in the house and you have a young child breathing in that secondhand smoke, that, in my professional opinion, would be almost the same as giving the child access to that drug, because that child, if there's enough secondhand smoke, then again, that child could, of course, become somewhat incapacitated. So this is something that's going to come up, and this is something you might see coming up. But this is something that, I would definitely litigate, because I think it's a very important issue. You're going to see CPS cases regarding this. So let's keep an eye on those things. Otherwise, we can move on.
Thank you, Mike. We'll move on to the next slide. Okay. Best interests. There's going to be a lot of overlap here between best interests and change of circumstances. They're going to be pretty similar in a lot of ways. Just like change of circumstances, you're not going to find any definitive list anywhere of things to be considered for best interest. There's case law where it gives you an idea of what to look at, but it's really kind of a cumulative calculation that the court makes based on the totality of the circumstances. I mean, obviously, one of the most important ones is going to be the relationship with each parent. who's the primary caretaker, who's more involved in the children's lives. Things like who gets them to school, who make sure they're getting their homework done, make sure they're being bathed and dressed and groomed properly, taking them to medical appointments, sports practices, making sure they're getting back and forth to school. Who is bearing the brunt of that load is going to be part of the calculation, and to the best interest of the child. Access to each parent. We talked about a bit with change of circumstances. If one parent is willing to foster that relationship with the other parent and encourage it and allow regular communication and things like that, the court's going to look fondly on that, as opposed to someone who's denying communication or anything like that, or being completely inflexible, not allowing the other parent to talk to the child, things like that. And intent to relocate, like we mentioned before, that the court will look at things, how established the child is in that school district, with their friends and things like that, whether it's in their best interest to relocate with a parent. Wishes of the children, that's one that is given some weight. The age of the child will determine how much weight generally. If the child's 16 or 17, the court is going to pretty rarely force a custody agreement on them. If we're talking about a young child, then we'll get into the attorney for the child in a second, but usually the attorney for the child, who is a separate attorney that will be appointed to represent the child in contested custody cases, and they will be allowed to basically to give their opinion of what they think is best for the child. That will be considered the wishes of the child. Ability and willingness to co-parent is another big one. If things have deteriorated to the point that the parents can no longer, co-parent at all, then it can be, in the best interest of the child for one parent to have sole custody at that point. Again, usually it has to be more than just general bickering or arguing or not getting along. It has to be basically a near complete breakdown in communication and an inability to agree on pretty much anything. And if that happens, then the court will have no choice but to award one person that decision-making authority. Also, the court will look at with communications, is one party interfering with the other party's communications? Are they listening in on phone calls? Are they there when the child's trying to communicate with the parent? Are they not allowing any sort of privacy? They'll take that into account. One parent is consistently talking bad about the other to the children, in front of the children, to their mother in front of the children, or if they are causing fights at exchanges or with their mother during during FaceTime or phone calls or any of that. If one party is doing that, the court again may view it in the best interest of the child for the other party to have sole custody. It is important to encourage the relationship with the other parent. The court likes to see that. One parent is making false accusations against the other, either to the children, if they're constantly trying to involve the police or CPS for illegitimate reasons, or spreading rumors or lies to other people. Again, that's something else that the court can look at there. Access to siblings, if one party has half siblings, that could play in their favor. If there's a good relationship, the court will want the kids to develop that relationship with the siblings. We'll also look at the support network of either parent, the close relationships with grandparents, cousins, things like that when determining custody, and how often they'll be able to see those people based on the arrangement. Educational opportunities, if the parents live in two different school districts and there's a significant difference between them, that could be something they consider. They'll also, again, look at school performance. how the child is doing on days when they're with each parent, absences, tardiness, things like that. You can go to the next slide. Okay, the fitness of either parent. Health of either parent, basically what we're looking at there is, can the parent physically care for the child? Is there some sort of, they have a young child with some sort of disability where they can't physically, bathe and provide for the child? That could be taken into account. Mental and emotional stability. Are there any psychological issues? If there are they being properly treated? Are there recommendations of a psychologist or psychiatrist being followed? Have there been any recent hospitalizations? Drug and alcohol use, as we talked about. Abuse and neglect. Has there been any CPS investigations? Have there been any charges brought for abuse and neglect? Any allegations involving the child? Domestic violence, again, what the court's really looking at there is if the children were home, if they witnessed it, if they were affected by it, is going to be the important thing there. Stability, is one party moving around a lot? Are they constantly moving new boyfriends or girlfriends in and out? Are they providing a regular schedule and routine, regular, dinner time, bath time? It's a young child, potty training, things like that. Is there just, are they providing a stable environment for the child? Existing arrangement is something the court will also look at. How long has it been in place? Have this been going on for 10 years now, or has it been going on for 6 months? They're going to look at what would need to change if there were to be a change in primary custody. Would the child need to change schools? How long have they been in that school? Do they have friends there? Are they involved in sports and activities and things like that? And if an agreement has been in place for a very long time, the court will be more likely to keep it in place. Financial considerations. Can the parent provide the basic needs for the child? Do they have somewhere to live? Do they have a bed? Can they feed the child? The court could consider, do they have a car or means of transportation to get the child to school and medical appointments and activities and all of that? And do they have child care for the child when they're working? Do they have someone to watch the child? Is something they'll weigh in there. The living situation of each parent. So they're going to look at the nature and the quality of the home environment. Is there suitable housing? Does the child have his own room or share a room or even share a bed? What's the sleeping situation? What is the condition of the home? Is there issues with insects, rats, bed bugs? Things like that. What kind of neighborhood the house is in? Is it in a dangerous, one person living in a dangerous area that's not safe for the child? Is something they can look at. Emotional ability to provide for intellectual and emotional needs. If one parent is causing the child stress, anxiety, depression, that will be an important consideration. And also, are they providing a healthy and nourishing environment for the child to be safe and develop in? The court's going to want to look at all that kind of stuff. Any special needs of the child? What they're going to be looking at there is the child, they have any medication? Are they being given that medication? Are the parents taking them to appointments? Are they cooperating with the doctors? Are they following any treatment plans? Are they both on the same page as far as meeting the needs of the child? Alienation and false allegations, kind of we touched on a little bit, but it goes to whether the parent is trying to encourage the relationship with the other parent or acting to its detriment. Excessive discipline is one. Excessive corporal punishment is usually what they're talking about there. Is the child being, hit excessively for punishment? Ignoring court orders, any sort of violation, withholding the child, or if you are not, you are supposed to be consulting on things and you're taking any sort of unilateral actions. Courts obviously do not like it when their orders are not followed. So that could be a major factor that plays into this. Other thing to look at here is the role of the AFC, the attorney for the child, and again, who is an attorney that will be appointed to represent the child. The child is their client, and they will meet with the child. They may or may not meet with the parents, depending on the attorney for the child. They will make a recommendation to the court as to what they think is either in the child's best interests or what the child wants. So there's, depending on the child's age. If it's an older child, they will generally represent what the child wants. If it's a younger child, they will substitute their judgment for that child and say what they think is best for the child. It's dependent on the judge, but it can weigh extremely heavily the opinion of the attorney for the child in the judge's ultimate determination. Again, some put more weight on their opinion than others, but it can be a very powerful factor. Another thing is if the child is of a certain age, either party can request what's called a Lincoln hearing, where the children meet in chambers with the judge, with the attorney for the child, in an entirely confidential meeting. And so the judge can ask the children whatever he or she may want and get their opinions right from their mouths, not have to hear it from any of the attorneys. And that's something they will do usually after a trial. It can be before, but they will hold a Lincoln hearing if they think it's necessary, if there is some ambiguity in what the child is saying. If someone is challenging what the AFC is saying, or some judges just like to meet with the child before they make a final decision. So that's something else that can happen. Mike, do you have anything else?
Okay. Yeah, a couple things just to add on to what Paul said is that with CPS investigations, now remember that if they come back unfounded, that means that you cannot even bring up or use in the court that there was a CPS investigation or any of the records from Child Protective Services. But that does not exclude you from putting in your petition accusations that you believe to be true. Just because CPS says that, well, it's unfounded, does not mean that you cannot continue and put those in your petition. So that's something that you have to put in if you think it's something that's abuse, neglect, or something of that nature. Secondly, with regards to wishes of the children, the big thing that is happening, and I'm seeing a lot, is that a parent believes that the child makes their own rules regarding seeing or visiting with a parent. Now, again, we're talking younger kids up to maybe 10, 11, 12, 13. Now, and then parties I would talk to would say, well, I'm not going to make them go. If they don't want to go, I'm not going to make them go. Well, you can't do that. Number one, because first off, you have a court order and you'll be in contempt of court. Okay. Now, the next step is going to say, well, how am I going to take my 13-year-old child who's 6'4" and plays on the football team? I'm going to go drag him out of the house? Well, of course not. But what should you do? Well, number one, you have to make sure that you cannot sit there and tell your child, well, if you don't want to go, you don't have to go. You just tell your dad or your mom that you don't want to go, and that's okay. You have to foster a relationship with the child and the parent. You have to say to the child, listen, this is your dad's schedule or mom's schedule. You have to go. Okay? This is your schedule. Your dad loves you or your mom loves you. You have to go. You have to do everything you can, with the exception of probably dragging someone out of the house, to go ahead and go see the other parent. Okay. If there's a reason that it's not happening, you have to file a petition immediately to modify the order. Otherwise, you'd be held in contempt of court. And what the judge is going to do is they're going to look right at Mike Belsky or Paul and go, counselor, your client's in contempt. Why didn't you file? This is an order. I signed this order. Your client cannot violate my order. So you have to come back here. Violation of a court order is probably one of the most egregious things that you can do, and a judge would really not look kindly on that. One last thing, the attorney for the child. I was an attorney for the child for about 20 years in Saratoga County. Couple things. Number one, you have to remember that the attorney for the child does not have to speak to either parent. Their only responsibility is to speak to the child. Okay? And you say, well, geez, we have a baby. What can they can't speak to a 2-year-old or 1-year-old. Well, what they're going to be looking for at that point is possibly how either parent interacts with the child. At that point, they very might want to speak to you. All right. And we get a lot of calls where one of the parties would say, well, the attorney for the child spoke to the law guard, one of the parties took the child to see the attorney for the child, but they didn't let me take the child to see the attorney for the child. Now, if you have a good attorney for the child, all right, I'm saying that in quotes because there's good attorneys for the children and there's bad attorneys for the children that, in my opinion, don't do their job. All right. And you can't, if you see that they're not doing the job, it's almost impossible to get them off your case. A good attorney for the child does not really need to speak to both parties. If they have, a young adult, they can get a lot out of the child. And if they've done it long enough, they can see right through what's going on. And what I mean by that, never, ever discuss with your child before they go see their attorney for the child what to do, what to say. It happens all the time. Make sure you tell Mr. Belsky about the dog incident. Make sure you tell Mr. Belsky what you smelt in your dad's car. Make sure you tell Mr. Belsky. And I got to tell you, the first thing when that happens to me, that just angers me and automatically gives me a bad taste in my mouth about that parent. When a child comes in, and I'll even ask them, well, what did your dad say you're going to be doing today? Well, Dad said I was going to come and talk to you. Okay, anything else? Nope, he just said Dad said to be honest, and that's what I'm going to do. If you do that, you're right behind the 8 ball, because the attorney for the child, like Paul said, could be your friend or your enemy. So be very careful. And the next thing, if the attorney for that child does speak to you, never badmouth the other parent. Happens all the time. Happened to me all the time when parents came in. They just jump right in and just want to start bashing the other parent. That's not what you want to hear. You want to hear, like Paul said, who can foster the best relationship between the child and the other parent. Of course, when you have a parent that comes in and starts automatically bashing the other parent, that's not the parent that's going to do it. Now, they can express concerns, and there's expressing concerns, and there's really bashing the other parent. Because you know what's happening if they come into bashing the other parent in front of you, you're probably doing it at home also. Keep that in mind. All right, so those are kind of a couple key things that I like to add to this. Okay, Paul, back to you.
And just one more thing about the attorney for the child. I always tell my clients when they're meeting with one, remember, they're not your attorney. You could tell me anything in the world, and we have attorney-client confidentiality. The attorney for the child does not represent you. They represent the child, and they can and they will use statements you make against you. So be careful what you're saying when you talk to an attorney for a child. Know that they are not representing you. You don't have confidentiality with them. And now we can move on to the next slide. Okay, common types of evidence. What we see a lot in custody cases is a lot of text message, emails, fighting back and forth, parties trying to show, how one party's treating the other, or what they're saying about the kids, or how they're cooperating or co-parenting. The best advice I can give on that is to just save everything. There's apps you can download that you can transfer your text messages from your phone to your computer, and you can just have a 1,000-page stack of text messages. Same thing with emails. There's programs where you can aggregate everything into one PDF. Save everything, document everything. If you have a conversation with that person, you think it's going to be an issue, they're going to say, if you agree to something verbally and you think later they're going to say we didn't agree to it, it's always good to send a quick text or email afterwards, hey, just confirming that we said this. And that's something that, can be helpful, because if it's just he said, she said, it's not going to get us very far. One thing I recommend a lot there is it's common for people to have problems at exchanges of the child if they're at one person's house or another. Get one of those Ring doorbells that records the interactions. If someone is screaming or causing a scene or causing that, you've got it on video. You don't have to break out your cell phone and put it in somebody's face and make things any worse. That's something I'll recommend to people. Experts were usually, talking about psychologists, therapists, evaluators, people like that, talking about the mental health of, usually if the court orders, again, we'll get into evaluations next, but that's usually as far as we go with experts in these kind of cases. Witnesses, you're really looking for people that can testify to the other person's behavior, around the kids. Have they seen poor treatment of the kids? Have they witnessed some sort of incident? You can call, if there's police reports, you can call police officers, teachers, if they've noticed big differences in the child on different days. Anybody who can really testify at all. Witnesses can be pretty much anyone that can help your case, but teachers in particular can be helpful, police officers, people like that just have come in with a certain level of credibility. But I'll say that probably the most important factor in these cases ends up being the testimony of the parents themselves. The judge's determination of the credibility and the character of each parent is going to be given great weight in making a decision. That's going to carry more weight than any evidence that you can really present, is how you conduct yourself on the stand and your believability and how you come off to the judge. Judge is a human being like anybody else. And I mean, they have all this paperwork in front of them, but they're watching you and, making their determination on you as a person at that moment. So I would say, stay calm, answer the questions calmly, answer what's asked. Don't get rattled, because attorneys will try to rattle you. Make sure that you prepare with your attorney beforehand, that you can have, mock cross examinations and be prepared for what you think they're going to ask, so you're not thrown off or rattled when it happens. I think that's all I have on that. Do you got anything, Mike?
Yeah, just to again piggyback a little bit. Now, like Paul said, the things that you have: emails, recordings, photographs, witnesses, text messages. Those are, again, any type of doctor's records, school records. But one thing that you really need to take into consideration, and I'm not trying to drum up business for us or anybody, but if the other side has an attorney, you really should consider, and this is going to be a custody trial, you really need to consider either requesting a public defender to represent you or hiring an attorney, because the judges have to abide by what's called the CPLR, and that is rules of evidence. And how you get this evidence in, like text message, emails, recordings, photographs, You just can't go up and say, well, here's this photograph, I want it into evidence. There's a certain procedural way that all this has to get done. And the other attorney, if they know what they're doing, is going to object and keep objecting. You're never going to get your evidence in. We have a lot of clients that call and they say, geez, I had a trial and I couldn't get any of my evidence in because the judge wouldn't let it in. And after talking to them, their evidence was really good. It might have won the case for them, but they couldn't get it in front of the judge because they did not know how to enter it into evidence. And if the judge had it in evidence, they might have won their case. Okay, it's the same way with witnesses. How do you ask questions? There's certain ways to ask questions if it's your witness or a different witness. And if you don't ask the questions properly, the other attorney, if you don't have one, is going to object to that witness answering these questions. And you might not get your testimony in that you really need. So, if the other side doesn't have an attorney and it says you and say your partner, okay, judges are pretty wide open and they most of the time are not going to, they're not going to object to one of you putting your own stuff in. They'll let you both get your stuff into evidence. It's the only when the other party has an attorney, and it's very important. Like I said, you really should look for an attorney if you really want to win your case. Secondly, just to piggyback on what Paul said about agreements, well, it might be in text message, recordings, or we have people come to us and say, well, we have a court order of custody, but my partner and I, we signed this agreement and we had it notarized. And now that my partner's not living up to this that we signed, that agreement really means nothing, okay? Because it's not a court order. If you're changing something, you can voluntarily do it. And if you live by that for, say, quite some time, the judge will definitely take that into account. But remember, it's not a court order. You can't hold the other party in contempt, and you can't move to hold them in contempt, or you could file a modification, say we've been doing this by this agreement, and you'd probably win on that, but the judge is not going to take that agreement that you both signed as a document that's set in stone because it's not a court order. So with these type of things, get it signed, get it notarized, but remember, it's not a court order. You have to go back to court if you want to get this into a court order. All right, Paul, that's what I have on this.
Yeah, and I agree with everything Mike said. I mean, when you're introducing evidence, there's a process to lay a foundation to show that it's authentic and it's admissible. And I mean, you're just not going to know how to do that. And the other attorney is going to keep probably pretty much all of it out. And the same with, you could have a great case, great evidence, you could have great testimony, but if you're asking the questions in a way that is improper, you're allowing the other party to just keep objecting and keeping it out, you may not be able to actually get any of your evidence or testimony in. So I completely agree with that. Okay, we can jump to the next slide. Okay, custody evaluations. So these are evaluations done by mental health professionals. It can be requested by either party, recommended by the attorney for the child, or ordered by the judge. The evaluator should be someone objective, doesn't have any prior relationship with any of the parties or children. And they should have credentials that show that they have some sort of specialized knowledge in child custody evaluations. How long the evaluation is and what it covers varies depending on the case. I mean, they can, but at a minimum, will interview usually both parents and the children. They can conduct psychological tests. They can talk with teachers, school personnel, visit homes. They can interview people who know the family. They can basically, depending on the case, conduct a full investigation. At the end, there is a confidential report that's submitted to the court. So the court would be able to use that in its determination. It's not determinative. It is one factor to be weighed, but it's something that the court will take pretty seriously. You can jump to the next slide. Yeah, so the evaluations, again, they usually come up in mostly, I would say most often where there's concerns about the mental health of the parents or the children. But if there's concerns of domestic violence, substance abuse, child with special needs, anything like that, they can be ordered. I'll say that these evaluations are increasingly rare. They're very expensive to conduct, and they can be hard to find people that do them in certain areas. So judges are pretty hesitant to order them, but in certain situations, they are certainly ordered. It depends a lot on the judge and the facts of the case, but not every case is going to be one that is going to have an evaluation. They're pretty rare in my experience, to be honest. We can go to the next slide. So tips for evaluations, what I tell people is basically treat it like a job interview. Wear your best suit, make sure you're all done up, you're looking good. Talk to your attorney before so you have some idea of what to expect. As Mike said with the AFC, you don't want to come off as coaching your children with any of this, whether it's talking to an evaluator or an attorney for the child or anything. You don't want to even give a hint of that. You want to stay calm, keep your children interests at the forefront. Don't complain about the other parent. Don't put the focus on them or how great of a parent you are, or go on any rants. Focus on your children and their best interests. Again, just like talking to attorney for the child, don't trash the other parent. Answer the questions honestly. You can ask for clarification if you need, and just be honest, and just like I said, like a job interview. Dress neatly, arrive on time, have everything you need with you, and be ready to go at the time of the evaluation. Mike, is there anything on evaluations?
No, I think you've hit it all, but like Paul said, they're very expensive, like very expensive. And I find that a lot of judges don't even read them, don't even really care about them. They used to be used quite a bit. Now they're used very sparingly at this point in time. And there's been a lot of negative press recently about psychologist evaluations and recommendations, because some of these psychologists, they do take sides. Unfortunately, that happens. They're not supposed to. So that's why the judges a lot of times have not really looked at these because they don't believe in them, or it's too subjective regarding who the evaluator is and what they're saying. But I've had very good success with evaluations and experts that I had. So the biggest thing, like Paul was saying, is that if there is going to be evaluation, number one, know the evaluator, know what background they have, right? Know if they've been involved with custody cases for a long time, right? Those type of things. You do not want in my opinion, you do not want a social worker to do your evaluations. I always make sure it's a doctor that does them, psychiatrist, okay, or psychologist. That's what I recommend. But number one, you're not going to get them paid for by the court. You're really not going to. I think it's still very hard to get the attorney for the child to pay for a portion. I know it's getting a lot harder. And then you're going to bear the burden as the parents to pay these expenses, and they can go upwards $5,000, $10,000, $15,000, $20,000. And in my opinion, they're really not worth it if you have the proof to put in otherwise. Yeah. That's it.
Yeah, I'll agree with Mike that the reason we mention it here, I think, is because a lot of clients do ask about it. It's something, if you go online and you search custody cases and stuff, it's something that, these evaluations pop up, but that information is kind of outdated at this point. I said it is hard to find people that even do them anymore. They're extremely expensive. They can delay the outcome of the case by 6 months or more while they're conducting these evaluations. And they don't, in some cases they're worth it, but it's a rare case where it's worth really pushing this issue. So that's what I advise most of my clients. Okay, that's it for me.
Great. Thank you, Paul. If any of the attendees want to submit any questions for Mike or Paul to answer, you can submit those using the chat function, which can be found under the chat bubble icon on your screen. Pause a moment for people to submit those. Paul, did we have any pre-submitted questions that you wanted to touch on?
Let me take a look here. Okay, yeah, I'll see one right off the bat that I can discuss here. So the question, states is this: as my custody order was changed after I got a DWI. I'm 2 years sober. I've gone through drug court and counseling. I only get to see my kids every other weekend. Is it worth it to fight for more time when the kids don't want to change the schedule? They're 13 and 16. I would say that you have the change of circumstances. If it's been 2 years since the DWI, sober, been through drug court, I think you have an argument to clear that barrier. Those are all positive things. The problem with that is with the age of the children, what they want is going to be weighed very heavily. If they are strongly opposed to changing the schedule, you're facing an uphill battle. Not impossible. There's a lot of variables in these cases. There's a lot of moving parts when you're talking about judges and attorneys for the child and things like that, and how they view things and come down on things, and how much weight they give the opinion of the child and things like that. But I would say that, I think that you've shown enough there where you could probably show that the circumstances are different now than they were at the time of the order. But as far as clearing the best interest hurdle, if the kids are adamantly opposed to it, I would say, not impossible, but it's an uphill battle. Mike, do you have anything you want to add on that one?
No, I'm good with that. I'm just kind of looking at other questions.
Yeah.
All right, we received one other in the chat. I'll send that over to both of you. And in the meantime, if any other attendees want to submit questions for Paul and Mike, please feel free.
I guess I saw a question that came up about if the child doesn't want to go to a parent in filing a modification petition. Well, as far as filing, so it really depends on, number one, the child's age. So I didn't see what the child's age was. In that question that came through, Pat. But, if it's, if the child's 15, 16 years old, of course, then you would file, because a 15 and 16-year-old, like Paul says, is going to have a lot of say in what the child wants to do. And as long as you're not trying to alienate the parent with regards to the 15, 14-year-old, you're fine, but I would file because you do not want to be held in contempt of court. Okay. And when the attorney for the child would speak to your child regarding that issue, they would basically tell the court, what that child in that range wants to do. And the court pretty much is going to abide by that. Okay. Now, again, if you're doing everything you can and the child will not go, and you can, write down in your papers, I've done everything I can, I tell the child to go, you would file because you do not want to be held in contempt of court. Now, what could possibly happen if you look to modify the parenting time? What else has been going on? Why does the child not want to go? If the child that says, I don't want to go, and there's no reason behind it, there's got to be some reason behind it. Now, if there's something going on at mom or dad's house, or they have a new boyfriend, girlfriend, got married, something else, you would also put that in your petition. And then lots of times what a judge might do in a situation like this, if it's a younger child and the relationship is broken down between the other parent and this child, they very well could order counseling with the child, the father, and the mother. Okay. And that does happen. So remember, the court, it's their position that it's in the best interest of the child to have contact and meaningful contact with both parents. So they're going to do everything that they can to see that happens. All right. But there's got to be some reason that there's behind a young child not wanting to go to see their mother or father. So make sure that you do file your petition, but word it carefully. Okay. Just don't put in there that, well, my child is this age and doesn't want to go see the father, and I've done everything, that I can, because that's not going to get you anywhere, because there's going to be a lot more information that the judge is going to want to know about, and the attorney for the child is going to want to find out about. And Pat, I have to jump out now because I have a consult to do. Okay.
All right, Michael. Thank you for your time.
Okay.
I'll take this. We've got the question here. My daughter told the AFC she's not comfortable or scared to spend time with dad on her own. No reason, evidence, words, behavior, other factors to explain this. Only her mother and her mother's parents watch her. Alienation over 8 years with the support of the grandparents. As Mike said, the AFC can be your best friend or your worst enemy. There's good ones and there's bad ones. A good one who's been doing this for a while should be able to pick up pretty quickly on a child who's being coached or has showing signs of alienation. Unfortunately, they're not, not all AFCs are created equal. So, I mean, I find myself in a situation quite a bit where I have my client telling me one thing, I'm hearing something else from opposing counsel, and a third story being told to the attorney for the child. So we're talking about children who will tell a lot of times whoever they're talking to what they want to hear. So it can be hard to get to the bottom of that. Really, the way to deal with it is to gather as much evidence as you can. Is there, what do you have to show this alienation? Do you have, any records, any texts, any emails? What evidence? Any lines of questioning you can go on to try to get this out? Is there anything you can introduce? A lot of times it can be a tough sell because it's done largely behind closed doors, and you're a bit reliant on the attorney for the child to catch it or the judge to see through it. So it can be a difficult situation, but I would say, gather as much evidence as you possibly can. And that, and hope that the attorney for the child can see that it's occurring. It's one of the more difficult situations we find ourselves in as attorneys in this area, is dealing with the attorney for the child in a lot of ways. Okay. Let me see what our next one is here. Last judge became ill, cannot adjudicate or divorce anymore. Recommended my daughter and I have therapy. Reasons not happen. Okay. So, I mean, if you have, again, the person asking the question here says that they have, recordings of, manipulation and alienation. I mean, that's a positive. Again, make sure you have an attorney. It can be very tricky to get videos introduced into evidence. There are different hearsay issues you have to deal with, and what that is statements that are made out of court under a lot of circumstances are not admissible. So we have to kind of find ways to dance around that. So getting it in would be your first issue. As far as the Lincoln also mentions requesting a Lincoln hearing. I think that's a good idea in most cases, and the judge would probably do that anyway. As far as the mother not encouraging a relationship or alienation and all of that, if the AFC is not seeing it, you're going to need to produce evidence of it or witnesses of it. Psychological evaluation, as we talked about, it's an option to request. Judges don't like them. They're expensive. They delay things. They may or may not get you anywhere. I think, again, as you're seeing coming up in these questions, the attorney, the institution of the attorney for the child is very problematic. And it's one of my personal biggest complaints about this area of law, and I think a lot of other attorneys agree, because they're all over the place as to how they conduct themselves, what they consider to be important and not important, how much work they put in, how good they are at picking up on things or not. And unless you have substantial evidence that you can submit to the court and get admitted, their opinion with a lot of judges does carry a lot of weight. So if you can't get them on your side, the only thing you can do is to really combat them with as much evidence as you have, and as much examples that you can go on lines of questioning about at trial and try to demonstrate it. We have anything else, Pat?
Well, that seems to be everything that's been submitted. Did you have anything you wanted to close with?
Yeah, I'll just say, like Mike said, and again, it's not, a pitch for me or this firm or for Mike or anything else, but custody cases are complicated. Litigation is complicated. You could have a great case, and if you can't get your evidence and your testimony in, you're in trouble. You have to know how to subpoena documents, question witnesses, lay the foundation for evidence, things like that. If you meet certain standards in custody cases in New York State, you can be appointed an attorney. So that's something to look on if your income is, I don't know what the number is, but if it's under a certain level. Otherwise, I would recommend not trying to go it alone if the other party has an attorney. These can get complicated procedurally, and they can also, just be honest, be emotionally and psychologically draining. So a lot of times trying to go it alone and conduct these yourself, you're just not going to be in the right state of mind or temperament, and it's good to have somebody else sitting there next to you to speak for you, who isn't as emotionally invested in it. So that would be kind of like Mike said, that I think that would be a big takeaway I would want people to take. Okay, looks like we have one more question. Let me take a look at it real quick. Okay, so again, we're back to talking about a child that doesn't want to go with another parent, and this is another common issue that we see, where there is a child that, for one reason or another, you'll see it with young kids. Sometimes they just don't want to leave mommy, and you'll see it, and it happens for any number of reasons. It can change from day to day, where kids really, they don't want to leave either parent if they're on a 50-50 schedule. They don't want to go back. They're happy where they are, and it's a pretty common thing. I think the thing is, like Mike said, is you have to encourage. You have to try to say, go with mom, go with dad. It'll be fun. You'll be back in a few days, and encourage that relationship, and try to foster it as much as possible. Now, if you're in a situation where the other parent is agreeing that, okay, I'm not going to push this. I'll just leave them here, and then, I mean, if they agreed to it, again, if you have this is why I recommend a Ring doorbell or something, because if they say I didn't agree, they withheld them, or anything like that. Then if they agree to it and just leave, then you're fine. I mean, if we're talking about, again, an older child, they're 17 years old, like Mike said. If it's a 6'4" linebacker on the football team, you're not getting him to do anything he doesn't want to do, and the court's going to recognize that. If you're talking about, a 3 or 4-year-old throwing a tantrum, I mean, you really have to obey the court order. You have to hand them over, and I mean, just, it's an unfortunate situation to see your child in distress like that, but I mean, you really have to comply with the court order. If the child does not want to be with that other parent, if you've got all this recording, and if they're going to tell the attorney for the child to that, file a petition to modify. But until that order is modified, follow it to the letter. Otherwise, the tables could be turned on you pretty quickly. Okay, we'll get one more here. Yeah, this is again, just the question is about, somebody who's had a divorce and custody case that's been in court for 2 years. They've represented themselves, and looking to retain a lawyer when it goes to trial. I'll say representing yourself certainly delays the process. A lot of times things aren't filed properly, and it definitely takes longer. In addition to just not really knowing how to get things in and go about the proper procedure. But this question has to do with the current plan is to retain a lawyer when it goes to trial. I would retain a lawyer as soon as possible. Depending on how complicated your case is, preparation for a trial can take months. There may need to be documents subpoenaed. There may need to be motions made, evidence gathered, witnesses subpoenaed and interviewed. And again, I don't know, divorces tend to be complicated situations because you're talking about property, you're talking about retirement accounts, bank accounts, credit cards, debt, cars, custody, support, alimony. I mean, they've got a lot of moving parts here. So I would say, and there aren't going to be many attorneys that are going to be jumping to take your case a month before trial. You're almost worried about it being malpractice at that point, because trial preparation, like I said, oftentimes, I mean, I will start looking at my calendar probably about, 3 months out, and see what subpoenas I got to get out, what motions I need, what witnesses I need. And then as you get closer, I mean, you need time to develop your direct examination, your cross. You got to work on your opening, your closing, your evidence. It is extremely time consuming. And most attorneys just don't have if you retain an attorney 2 weeks before trial. I mean, I look at my schedule, and I don't really have much open space in the next 2 weeks. And I think that's the case for most attorneys. So the preparation time alone, you're going to need to hire somebody And I mean, you really don't want to hire an attorney that has the next 2 weeks completely open. That's probably not a good sign either. You want to give them as much time as possible to represent you. I would not wait on retaining an attorney. Okay, Pat, we have anything else?
That is all we have in chat, so I think we can close things out. Thank you, everyone, for joining today's webinar, and thank you to Michael and Paul for taking the time to present. We'll leave our contact information up on screen for a few minutes as we close things out. If you're interested in speaking with an attorney from Tully Rinckey about a matter you may be facing, you can contact our firm at the number on screen or through our website at tullylegal.com. Today's webinar was recorded, and we'll be sending that to all attendees as a follow-up via email. Again, thank you for joining, and we hope you found today's presentation helpful. Have a great day.